will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the three senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 45B of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285 sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 45 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses in election petition proceedings is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bits, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in Oke and Mimiko, citation supplied. In his contributory judgment in the above case, Clara Ogumbi JS retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt, which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 135 Act have been totally foreclosed from any amendment, which was in fact the hidden agenda promoting application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, Parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation, seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of Section 285 sub 5 of the Constitution and Section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4(1) and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration? The obvious answer is no. Such provisions like Section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citation supplied, this court held that application of time to call additional and file additional witnesses' statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citation supplied. Compel the impossibility, and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned respondent, A.B. Mahmoud SN, subpoenas and the effect and purpose of 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4(5) of the first schedule to the Electoral Act 2022. It is on this note that I hold that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' coalition agents at the court below. The appellants are aggrieved by the verdict of the court that witnesses a hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC citation supplied, this court, per Agim JCA, as it then was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, PW1 was not a polling agent. He was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or principal, having regard to the fact that no mortal can be in all the places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22, who were state and national coalition agents of the petitioners, can only testify of the events in their units or coalition centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the coalition agents in this instant case, who are PW1, 2, 5, and 2 and 7, relating to suppression of votes, multiple thumb printing of ballot papers, entering of wrong scores results, disruption of voting, are inadmissible hearsay and are hereby discounted as end of quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Jimobi, and others cited. From the evidence on record, it is indisputable that PW1, 2, 3, 5, and 7, who were the appellant state coalition agents and national coalition agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence, analysis of PW1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity, and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Messrs. Adejo and Governor Yahaya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim Audi Alteram Partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present the election petition, 3, state the holding of the election, the scores of the candidates, and the person returned as the winner of the election, and 4, state clearly the facts of the petition and the grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For in keeping with the Audi Alteram Partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Ekonife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16, sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yahya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi. Head of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134, sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than 2 candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners. That the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondents averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 184, sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than 2 candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citation supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the results put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7. which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties and probably their counsel should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment. Thank you.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed. And I also did not make any order as to cause, but affirmed the judgment of the lower court, declaring the second respondent, Bola Ahmed Tinubu, as the duly elected President of the Federal Republic of Nigeria in the election of the 25th of February, 2023. Thank you.
My learned brother to my immediate left will deliver his judgment.
The late judgment just delivered by my learned brother Okoro JC has comprehensively presented all the points I made and the views I expressed at the conference of the honorable justices of this panel over the appeal. He has very proficiently presented all the views which I express in respect of all the issue in both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself. But I would like to say that the point raised by the learned senior counsel for the appellant, Chief Chris Uche Ezean, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting, attractive, but when taken along with the relevant provisions of the Constitution, as well as the Electoral Act 2022, it, with respect to Chief Uche Ezean, spacious. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named Presidential Election Petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it's coming up, and it is good that this court will make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite reasoning and the conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Okay. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal. as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application too is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Iam Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSC.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Inyang Okoro, JSC-CFR. I completely agree with the reasoning, conclusions, decisions, and others therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views. That the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed a certificate of reporter bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings, and if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court because of the peculiar circumstances of this case, and adopted as a deposition ordered to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, as so authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku Abubakar for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the district court, or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said district court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, the deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in the election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part that the words can truly support the wordings used in that provision. That is how to read a constitution. Yet remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal. I call the next one.
SCCV 937-2023, Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC respondents.
Appearances.
The Lordship, my name is PIN Ikweto. My Lords, unfortunately, we have a type list of counsel. And by the time my colleagues brought it to the registry, they were told it was late. If Your Lordship allow me, can I submit that list?
Please, submit it.
Thank you, my Lord, sir. And my Lord, with respect,
Wait to judgment day. We don't go late to court.
I was here before. I was there by 8 o'clock, sir.
So that you won't be late when God will be giving judgments.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone. So I will not be late there.
So,
And I'm sure He will accept me when I get there, sir.
God will accept you.
I'm sure He will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is PIN Ikweto, and Your Lordship, with respect, we have, in line with Your
I
Lordship.
think we should start calling you Saint Ikweto.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
I don't see, please. My Lord, I don't know where we can discuss that, sir. My Lord, we've taken the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my Lord, Alex Ejesieme, SAN.
Azinge.
Yes, sir. Azinge is number 3, sir.
Yes.
Number 4, my Lord, is Alex Ejesieme, SAN.
Where is Azinge?
My Lord, Azinge is just beside me here. She's been here all morning with me.
Azinge used to be black. I don't know why she's white today.
No, she's always been fair complexion. Always. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a lot of places, yes, sir. She's been fair complexion all along.
It's okay. You're welcome.
Yes, my Lord.
Leonard SN Ikweto, did you say Valerie is number 3?
My Lord, on the list, she's number 3.
But she's number 2.
She's number 2, yes, sir. Yes, sir. I just want to make it easier for my Lord, sir. The next, my Lord, is Mr. Alex Ejesieme, SAN.
Yes. Chike.
My Lord, as a Chike AOB Esquire.
Yes.
And my Lord, lastly, and in compliance with my Lord's directives, Ejiofor Onwaso Esquire. The Lord's appearance with due respect is for the appellant in this appeal.
Yes.
May it please my lords. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my lord.
Stephen.
Adehi, my lord. Sir
Okay.
Stephen Adehi.
Leave that thing. Adehi.
Yes, my lord.
Yes.
I appear with my learned friends of the Inner Bar.
Yes, yes.
Al Hassan A. Umar, SAN, is number 4 on the list.
Umar.
Yes, my lord.
Yes.
And number 7 is Wendy Kuku, Esquire, my lord.
Yes. Yes.
Number 8, Jamiu Aguru, Esquire.
Where is Jamiu Aguru?
And finally, number 10, Z.U. Obansa, Esquire. Our appearance, my lord, is for the first respondent. May my lords be pleased.
Is that for the... Yes. Tell those guys this. Tell them that this thing can amount to contempt of court, so they should be careful.
My lord, the last person on our list, my lord, is actually number 9, Amira Hamisu, not Obansa. Number 9.
Who?
Amira Hamisu, Esquire. Yes, my lord. Not number 10, my lords. Thank you very much, my lords.
1, 2, 3. Amira. Hamisu. Yes.
If it pleases my noble lords, my name is Akintola Makinde, and I appear with my colleague, Okpe Moritala. Your lordships, we submitted a typewritten list in the morning. Very respectfully, our appearance is for the 2nd and 3rd respondents. We are very grateful, sir.
Okpe.
Okpe Moritala, my lord, is number 2 on the list.
Yes.
We are very grateful, sir.
Yes. Yes.
Respondent.
Yes.
Appear with me, I'm learned friends. My lord, I'm sorry, the next name is not on the printed list which we submitted.
Let me, okay, here.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi.
Yes. Well, in this appeal, we have, during conference, noticed that issues number 1, 2, 3, 5, 6, and 7 in this appeal have been dealt with in Atiku's appeal. It is the decision of this court that this issue shall abide the outcome of the issues as resolved in Atiku's appeal, mutatis mutandis. As for issue number 4, which has to do with double nomination, which was not in Atiku's appeal, it is the view of this court that this issue, having been dealt with by this court in S6-CB, so 501/2023, which judgment was delivered on the 26th of May 2023, this court cannot allow the matter to be relitigated in this very court. There must be an end to litigation. For us to sit down now and talk about when this man resigned or did not resign, when they did a fresh conference or fresh primaries to replace him, which we have done before. We are not going to do it again. This matter ought not to have come here. When the matter was pending at the trial court, this court delivered that judgment. If you read the judgment of the lower court, they mentioned it, that Supreme Court has settled this matter. And that should have been the end. You now bring this issue of double nomination for us to sit on it and write another judgment. This is not how it should be. This appeal lacks merit and is hereby dismissed. My Lord, to my right, Abaji.
I agree with my learned brother, Justice John Ian Okoro, that this appeal, number SCCV 937/2023, Mr. Peter Gregory Obi and the Independent National Electoral Commission lacks merit, and it is also dismissed by me.
My Lord, Garba Jesse.
I also totally agree with the lead judgment that this appeal substantially canvass the same issues with the appeal number 935/2023, which this court has very comprehensively dealt with. And there is no need for us to repeat ourselves because the issues are the same. The only issue that's different, like pointed out by my learned brother, the PJ, is that about double nomination, which you have settled. And we do not intend to reopen it again in this appeal. On the whole, I also join the lead judgment to dismiss this appeal for lacking in merit.
My Lord Salawa.
Having had the privilege before now of reading in draft the judgment prepared and delivered by my learned brother Okoro JC, I cannot but concur with the far-reaching reasoning and the conclusion that has been postulated in the judgment to the effect that the instant appeal lacks merit, thus ought to be dismissed by this court. Having associated myself with that reasoning and the conclusion, I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
My Lord Jauru.
Well, I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother, John Ian Okoro JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is devoid of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My Lord Abubakar JSC.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My Lord Hakim JSC.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rise.
Ella.
Like the judge said, all litigation must come to an end. They addressed all the issues, about 7 of them, and those issues were, and the judgments on each of the issues were clearly unassailable as far as I'm concerned. So for me now is the time for us all every Nigerian, particularly the president, to roll up his sleeves and continue with the governance. This has been a distraction. The litigants exercise their rights to go to court, but that has come to an end now. We now have to all come together as one country, one people, and move ahead and take this country where it rightfully should be. We're happy. We're excited.
So coming together, does
yes.
that mean that you'll be extending a hand to the PDP and the Labour Party? Although the APM's appeal was dismissed, but would the president be extending a hand of friendship or sportsmanship to the other political parties?
Well, listen, we shouldn't take these things personal, right? If you listen carefully to the judgment was very sound. By any objective, right-thinking person, supported with facts, with cases, with statute. The president, if you know him very well, is a Democrat. It's not now that he's extending his hands of fellowship. He's always done that. He will continue to do that, and will continue to do so on his behalf. Governance is about everybody. It's not about a party. It's not about an individual. And if we do not come together now, then we'll have ourselves to blame. Opposition is not, you don't oppose for the sake of opposition. Elections are over, litigation is over. All litigation must come to an end. Now is the time for governance. Distractions over. So yes, Mr. President, the APC, and all rightful thinking members of the society must come together, no matter what party you belong to address the issue of governance.
Thank you very much.
Thank you very much.
Sir. Excellent, sir.
Okay. Well, I want to first give all the glory to Almighty God for this judgment. It is indeed another day that the Lord has made. We're glad that this puts an end to all litigation and a closure to all the speculations and all that. Mr. President, in his magnanimity, I'm sure will now reach out to all to join hands with him in his renewed hope agenda. APC was his platform, but the Nigerian state is where he's president of. So this is not just a victory for our party APC, it's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the Appeal Court. Their judgment was very detailed, it was very meticulous. It laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. They were straight to the point. And I believe that this judgment would be seen worldwide as that which is in line with global best practices in law. I want to salute them again because, they are the bastion of hope for everybody, including the common man. And this is a victory for democracy. Opposition can now go and rest. If they indeed mean well for this country, I expect that after today, they will call President Bola Ahmed Tinubu. They will congratulate him. They will now sit down and fashion out how to join hands with him in ensuring that indeed we achieve and continue to achieve our pride of place in the Committee of States across the length and breadth of the world. Once again, I congratulate President Bola Ahmed Tinubu for this victory, and I congratulate APC. I congratulate Nigeria. Thank you very much for having me. Thank you.
Yes, just one question.
What is it? Yes.
The way today said that the FCT has no special status. As the minister of the FCT, what do you have to tell me?
Maybe you don't understand what he said. FCT has no special status. What he said that in terms of calculating or having the special square, you must not win FCT before you are declared president of the Federal Republic of Nigeria. That FCT is like another state. So that you don't need to say, oh, if you don't win FCT, therefore you cannot be declared. That's what he said.
So you must have this start with the APC, how many players said that you have moved to the APC?
I didn't come with APC crew. And in the court here, in the court here, I don't know where they said APC and PDP. I came here as somebody who's interested, as somebody who wanted the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. So Mr. President can focus and do what he's supposed to do for Nigerians. Thank you.
Thank you.
I just want to
election litigation and the delay it seems to constitute election litigation and the delay seems to constitute distraction. Will you be moving for some form of amendments?
Well, you see,
what's your advice to your opponents?
well, you see, this is a developing democracy in a developing nation, so you expect such distractions to occur. But I believe we fine-tune our laws, especially electoral laws, and and we believe we shall come to the mature stage that we are expecting. Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use this opportunity to congratulate politicians, congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so, rather than taking, arms against, against each other. So we have to congratulate our politicians for resorting to judiciary, and the judiciary has done well. It means that democracy is getting matured in Nigeria, and we are happy with that.
Many thanks, sir. Thank you.
And that has been the proceedings from the Supreme Court here in Abuja. Shola Shoyele reporting for Channels Television News.
be watching a live Channels Television event. Stay connected to the world with Channels TV Podcast and get all the trending stories. Simply log on to channelstv.com, click on podcast, select the program of your choice, and listen. Our podcast is available on Apple, Google, and Spotify. Tap the expertise you trust. Touch the stories that touch you. Anytime, anywhere. It begins when news breaks, but there's much more than the details. That's where Special Report comes into the picture, locating the source and destination of the news.
Something needs to be done. We don't need to negotiate that. Government should see what we are doing.
Bringing your perspective to the fore.
If those arrested are those protesting against police brutality, I would say that such arrest is unjustified.
Exploring angles that may provide solutions, giving you the opportunity to understand the issues and make decisions. Watch Special Report on Channels Television. Our website, channelstv.com, has more information on our top stories and others. Subscribe and watch Channels Television's live stream on YouTube and your mobile device browser, or download the Channels TV app for Android and iOS devices from their respective stores. You can also watch us via your smart TV platforms on Apple TV, Android TV, Fire TV, and Roku. Channels Television, ubiquitous.
This week on Tech Trends, we put the spotlight on Queen's College's Team Aurora, which is an all-girls robotics club that participated in the 2023 First Lego League Asia Pacific Opening Robotics Competition in Australia. And then there's my interview with Dayo Adesonya, Head of Tech Innovation at Cloud and Prem, and we talk about the rise of generative AI and the concerns surrounding its use. A warm welcome to the program as we seek out innovation and creativity that are unique to Africa. I am Olayemi Utunuga.
We need technology in every classroom and in every student's and teacher's hand, because it is the pen and paper of our time, and it is the lens through which we experience much of our world.
Oro Dam, a self-recycling hydroelectric dam for the generation of electricity, and Oro Cleaner, a sweeping robot. These are two innovative projects designed by Queen's College's Team Aurora, and which they presented at the 2023 First Lego League Asia Pacific Opening Robotics Competition in Sydney, Australia. The girls were the first to represent Nigeria at the championships.
This is Queen's College, Lagos, a government-owned secondary school in Yaba. But it's not just the traditional education that goes on in here. The school has a STEM and robotics club codenamed Team Aurora. In here, the girls engage in hands-on STEAM activities that foster the critical thinking, problem-solving, and creativity skills. It is also in this room that the girls came up with an innovative project that they presented at the 2023 First Lego League Asia Pacific Opening Robotics Competition in Sydney, Australia. Queen's College's team Aurora was the only all-girls and only African team represented at the championships. It was also the first time Nigeria would be represented at the competition.
We didn't come back with a cup, but we go in there, we were winners. Like we came back as winners because we being the only African schools there is a lot. So we took ourselves as winners, even though we didn't carry any cup. But the fact that we went there, we experienced a lot, and we came back, we are winners.
The team had developed a solution based on the designated theme for the competition, Super Powered.
Super Powered is all about finding the solutions and problems based on the transmission of electricity. So we researched on how electricity is transmitted, how it's generated. We actually found out during our research that there are actually three processes of transmitting electricity: the generation, the regulation, and the transmission. So we came up with an innovation project, Orodam, which is self-recycling, and it uses water as its renewable energy. We use this project to solve the problem of the epileptic power supply in Nigeria. This project is actually affordable, is mobile, and it's detachable. You can move it anywhere. And it runs on water, which is renewable energy.
This is Orodam. Orodam is a self-recycling hydroelectric dam. It has two compartments. The upper compartment, which serves as the reservoir that houses the water, and the lower compartment, which houses the turbine. The reservoir has two inlets and one outlet. The inlet is used for recycling purposes, while the outlet is used to release high-pressure water on the turbine. As water leaves the reservoir, it flows through the outlet and hits the turbine, which spins the turbine, producing mechanical energy. Mechanical energy is then converted to electrical energy using the alternator. It then takes it to the step-up transformer, which increases the voltage, and to the step-down transformer, which regulates this voltage, depending on the level of consumption. In the lower compartment, two pressure pumps are attached to it to recycle the water back to the reservoir. It also has an outlet, which is used to remove waste from the lower compartment. This produces electricity.
Apart from being innovative, teamwork and collaboration are two skills that the girls demonstrated. But it wasn't easy getting to that point.
Initially, working together was not an easy task, as we are all from different grades. But as time went on, we learned that working together was truly the best, as that is the only way we could achieve a common goal.
It also wasn't easy for the girls to complete the task, as they come from different classes and disciplines. But with their dedication and passion, they were able to work together.
We have different timetables. As an art student, my timetable is different from those in science. So when we are in science, we are in art, and they are in science, we all come together. Like for biology now, I offer biology, but I'm an art student. So maybe during biology period, when our teachers are not in classes or we don't really have things to do, we come here, then go back to our classes and meet up and copy notes. We had times, we had routines for everything. We always have the time, even though we come here, we don't allow it to affect our studies, because during CAs, we give ourselves break. Like
Supreme Court on Monday had the case filed by Atiku and Peter Obi. Oh yes, this is what we got from the sitting. 5 of the judges out of 7 did not say a word. They just sat there like Mumu Clarence Thomas of the US Supreme Court. Nothing. But the judges also banned foreign journalists from coming into the court. No, I don't understand those old men. I don't understand. As if that will stop them from writing their stories. I don't get it. But they think that way. Anyway, one of the judges, Justice Okoro, asked what they should consider. The letter from Chicago State University saying that Tinubu graduated from the school, or what was said under oath during the deposition by the registrar of the university. Yes! That is a judge asking us and the lawyer to Atiku. Yes, whether he should accept Tinubu's, what he should accept. If the person asking this question is a market woman, you know, I won't be troubled. But a judge of the Supreme Court, hey, he does not know what is more powerful. Something typed on a piece of paper, you know, Joleba, or something said under oath. Anyway, the honorable justices after that reserved judgment. But we do not need them to tell us what the judgment will be. We don't need them to tell us. In a few days, they will write up something and call us to listen to them, read it. After that, their supporters will tell us that they are the highest court in the land and we must obey whatever they say. That is when we will tell them that we the people, are the sovereign in sovereign states. Sasha! Tweet that out. This is deep. The people are the sovereign in the sovereign states. Without the people, there is no sovereign. Hey!
And I am ready to die defending Nigeria in whatever way. When it is God's time for us to go, it is
and you
no
took
more
my
going
time
to
to
be
God. You are ready to defend Nigeria. I gave you my time.
No,
Please,
I'm coming.
please.
I'm coming.
Alexi, hold on. You already started.
What I'm saying, defending Nigerians is this.
I gave him my time and he's using it to defend Nigeria.
No, sorry. I'm sorry.
Tinubu is a criminal, yes, of course, a categorical grade 1 criminal. The only person more criminal than Tinubu in Nigeria is probably Babangida. But he's a criminal, and is he fit for purpose? Absolutely not. Should Tinubu be the president of Nigeria? Categorical no. Is there a better option than him? That is subjective. So show me who he is.
Tó fẹ́ kú torí ẹ̀. Ọwọ́ ẹni ló ti ṣàánú kọ́. Ayé la bá, ayé la fi sílẹ̀ sí. Ọ̀nà èyí yóò.
Welcome to the courtroom of Justice HBC Onwatuebo. This is the letter of the law. Even though you cannot find them all, you must search for all the facts. After that, you must act based on the stance of your conscience and not the grudges of your indifference. Don't let the judgment that is coming tomorrow prevent you from seeing the truth buried in the caves of yesterday. Even we, the so-called court of last resort, cannot see the end of tomorrow that passed. The rest of your life changes today. But to understand it, you must have the instinct of a soothsayer and the wisdom of a child. The only difference between a suspended sentence and a suspended justice is that the former expires with time, while the latter doesn't. Truth offends the unjust, while the reward of the just is eternal contentment. Thank you so much for watching. Thank you. Have you subscribed? Yes, you. Have you subscribed? You. Yeah, before you go, click. It's free. Click. Just that's it. Have you subscribed? You are laughing. Have you subscribed? Have you subscribed? Thank you. Thank you. Thank you. Hey, madam, thank you so much. I can see you. We have to get to 100,000 subscribers. This by the end of the year. How are we going to do that if you don't subscribe? Yes, you. Yes, you're about to click off. Why? Have you subscribed? It's free. If you don't, ask your son, ask your daughter how to. Just one click. Thank you. Thank you. I see you. Aha. Thank you very much. Thank you very much. I'll see you tomorrow.
That's a good question. That's a great question. I don't know what is wrong with them all. Hey, I don't know what is wrong with them. Somebody is asking for where you do your course and you are sure you did your course there. I agree with you. But a lot of what we hear, because you didn't hear this direct from Tinubu, because you know lawyers are very funny. Sometimes lawyers will say, you must not say this. I mean, you know what is happening to Donald Trump right now? Donald Trump that guy is walking himself to jail. And he is coming down to say that, oh, well, it was my lawyer who said it. It was your lawyer who said it. It was your lawyer who said that you should march people to the Capitol and stage a coup. People who stage coup in Nigeria, they never live to tell the story. That's what I tell them. They never live to tell the story. They are summarily tried within a short time and sent to jail or made to face the firing squad. That is the way it works. But it's only in America where somebody put a gun to your head and you say, all right, well, you are quoting the First Amendment right. What is First Amendment right? What is it? I don't understand. So I don't know why he's denying Atiku the chance to go there, because the news media, they tell a lot of lies, things that are not true. I knew this man went to Chicago State University. I knew that. I won't like
Dr. Wumi, if you were aware of Tinubu when he was at University of Chicago.
Yes.
Can you elaborate on us the accusations whether he was actually distributing drugs and was a drug dealer in Chicago in those days? What do you know about this?
Okay, thank you, sir. I heard about it, that he was distributing drug, and I know a lot of people who distributed drug. Who was the girlfriend of?
But let's be more specific. So look, we've all heard that Tinubu was a big drug tycoon. We have all heard that. What kind of specifics? I mean, when you say you heard that from people, were your friends the ones who were buying from him? Did he tell them that he was selling? Like what can you tell us as a distinguished man around that area at the time when Tinubu was there? What can you tell us that he was really up to?
Well, what I tell you, I don't know whether, in fact, the first time I saw drug, I thought it was in Lubon.
Sheikh Ahmed Gumi doubled down the other day on those calling for him to be arrested over some statements he made about Christians and Satan worshippers while preaching recently. Yes, people like Femi Fani-Kayode. Now, to those people, he said, "Hawk my brain." The one said he would not reply to those riffraff and called them idiots. I know. His exact words were, "I should not have replied for idiots of democracy." Hey, idiots of democracy. Now, what pissed so many people was that Sheikh Gumi said Christians and Southerners couldn't be trusted with Nigeria's security. The man had his reasons. He said Christians worship Israel and that Israel worships the devil. wait. I'm mixing things up. No. The man said that Wike, the minister for the Federal Capital Territory, Abuja, was a satanic person. Now, there's a difference between worshiping Satan and being satanic. People should know this. You are worshiping Satan if you think it doesn't matter what the real name, the schools, the parents, or the degrees of your president, but feels that it is very important to know how Peter Obi, with a pass in math and English, got into the University of Nigeria, Nsukka, to study philosophy. You are worshiping Satan. However, You are satanic. If all you want us to do is to move on to a place where $1 is equal to 2,000 naira. That's satanic.
This is not a joke. It's not a turn-by-turn thing here. I wouldn't be here. After this election, stop coddling Sowore and having him running his mouth. He cannot win a single local government. So
you are the one running your mouth. Stop, be respectful to Sowore. Are you mad? Are you alright?
Mute that guy. Mute him. It's my turn.
Are you mad?
Mute that boy right now.
Amari, hold on.
Mute that son of a bitch.
No. No. Pansa, no, you don't say. No, this is not good. You see, this what I think I've said, why do you people want me to be making commentary, editorial commentary on this? This is your chance to speak. But you guys are making me to make editorial commentary. Why do we think that, hold on, Pansa, hold on. I'll call you when I'm done. Hold on. Everybody hold on. Why do all of us think that we are that important? Anybody, whoever you are. Why is this? Do you think this election will? I've seen the world. I don't know where you live. I don't know how you study history. I've seen the world. Nothing. This is not the end. This is not the end. We can't allow people to come here and talk this way. It's not good. You can make your point and quietly, and people will get your point. You understand? Nobody. No, not yet. I'm not finished. Maybe I'll start treating this as like a classroom. I teach a class. Nobody can speak like this in my class. It's not possible. But I just know that I want to engage. I want people to have conversation. I want to make it free. I don't want to start putting people, banning people, stopping people from talking. I don't like that.
Farotimi, I disagree with him. Obi cannot tell us he's not probing the rest people. In as much I know that offices will take care of it. As the commander-in-chief, he should let us know that they will probe from 1960 till date. And the people that need to do the job, he will make sure they do the job. But giving us a message that you are not going to probe it, that is a bloody lie. The truth is this: if Obi own Nigeria as his business, and all since 1990, 1960, he has been giving it to different managers to manage. And they've been stealing and looting the destiny of his business, which is the future of every one of us, including our unborn children. And now he has the opportunity to take back that business. And he knows those who stole from 1960. Will he keep quiet? I believe in doing unto others what you want others to do unto you. Mr. Obi, do unto Nigeria what you want Nigeria to have done to your business. Period.
Wow.
Then two.
Is it just me or
the thing is this?
See that she has the Facebook?
There are two things that will take place. One, is a must. It is either we allow peaceful revolution by ballot or bloody revolution. And I will go and lead that protest. Nobody kills me. We must build a new Nigeria, whether they like it or not. And if they think after casting chaos in Nigeria in 2023, they have this Obodo to come, it's a lie. We will drive them from the airport. It is a must. Oh, they looted our destiny. Then they now think it is time We have all woken up, even though all Nigeria have not woken up. But some of us who are ready to stand in the front, we fear no bullet, because no one born by a woman can kill us in the journey of creating a new Nigeria. A Nigeria of my dream. My father left it unattended to. My grandfather left it unattended to. I and my brothers and sisters, we refuse to live in this way for our children. It's a must. A new Nigeria is a must. We are not black monkeys. We are intelligent. We are smart. We are brilliant. We are courageous men and women. We are king. The black race, we are king. We are prince. We are princess. And we are prince. That is who we are. Why did we allow mediocrity to turn us to be mumu? I refuse, my brothers and sisters. Let's wake up from our mumu easy. We are king. We are prince. We are queen. We are princess. That is who we are. And we are so smart. We are so intelligent. We make the Western world who they are today. Let us go back home and see what will happen today. Why should we develop another people nation and leave our own for the stupid, greedy politicians and the useless GOs that have turned us to become nothing? They beat us and rob us of our destiny. And they had the audacity to tell us not to cry. The kidnapping, the Yahoo Plus, the Oloshos, the hookups, the bandits, and the Boko Haram. That is the cry of Nigeria, telling them they have looted our destiny. Why should they? Can a woman beat a child and you say the child should not cry? They have beaten us. People like us, that the good Lord has made it possible for us to come and see the difference and see what they have done. We have chosen to say we have learnt enough. It is time to go home and rebuild Africa. Africa is supposed to be the best continent on earth. And in my lifetime, I will work with my brothers and sisters who believe in me, and we shall make Africa the pride of our continent. They are not better than us. We are not slaves. We are kings. We are queens. We are prince and princess. That is who God created us to be. That is why you can bleach this to white, but you can never bleach white or black. That is the greatness of God upon us. He has blessed us with everything we can think of. All natural resources, good weather, and human capacity. It's what it takes to build a great nation. And we shall build Africa. Nigeria is the giant of Africa. When we get it right, every other African country will follow suit. The political terrain, we are about to dismantle their so-called stupid ideological thing they have used to cage the destiny of the African child, and for the useless GO that has turned their tummy to become their billing, giving us wrong messages that are false just to collect the little from us. They have used the weapon of poverty to cage us to too long. But we will get our economic power back. The Lord has given me something for that, and we shall use it. By the time we get our economic power as young men and women, with the number we have, 2027 is a
Peace prize up for grabs next year.
Chancellor.
It is for anyone who will solve the Israeli-Palestinian conflict. Now, since politicians
all right,
tried,
thank you so much.
Times, in Washington D.C., in Oslo, Norway, and failed, I began to think that maybe, just maybe, men of God could get us peace in that troubled region. I was optimistic when Pastor Enoch Adeboye of the Redeemed Christian Church of God went to Israel to make peace. Yes, he did. He met with the Prime Minister Netanyahu and told him that God sent him to Israel to bring peace that passes all understanding. That was That was 2011. Yes, obviously. I know. Look at the headline. We don't make these things up. Look at the headline. Yeah, he did. Well, of course, Adeboye failed in his mission. So it was therefore appropriate that when the new conflict, the new fight started, that Pastor Adeboye should pray for permanent peace. And he did. Look at the video.
The Almighty God, the Holy One of Israel, will give you absolute victory and give you permanent peace from now on in the mighty name of Jesus.
Yes, the man is consistent. Unfortunately, some bullies made the man of God to delete that video. No, I don't get these people writing comments. Anyway, I went out searching for a man of God who has what it takes to bring peace to the Middle East. I thought of the one that fries his hair. I'm talking about, what's his name? Reverend Chris Oyakhilome. Chris Oyakhilome. But his brain is so cooked with 5G waves that he cannot do the job. I don't think he can do the job. And that was when I remembered the great Ndaboski. Yeah, Prophet Odumeje. He has been quiet since Soludo's task force roughened the man up at a demolition site of one of his churches. remember when it happened? Watch. I know. I called his office to find out what he thought about leading a peace mission to Israel. You know, here is the video in response to my request. Watch.
You have never even prayed. Your president, we don't know left and right. Pray prayer for your country. If I hear your pain, any pastor here Israel, I pray for you. Make it over.
Yes, I'll try to translate, but with every translation, the real gist is lost in translation. Yes. Now, in the video, Ndaboski ordered all Nigerian pastors not to pray for Israel until they first solve the problems of Nigeria. Now, if you disobey his order, he promises that what will he do? That he will make you deaf and dumb. Yeah. And you wonder why we are the way we are. Africa, who did this to us? Right. It's Thursday morning here in New York. My name is Rudolph Okonkwo. It's 8:02. Welcome. We want to have a brief conversation on the ruling of the Supreme Court of Nigeria in the case of Atiku and Peter Obi against the election of Bola Ahmed Adekunle Tinubu. The Supreme Court dismissed the case, and Tinubu is now going to be the president of Nigeria, at least for the next 4 years. What do you think? Yes, what do you think? Judge Bernard Shaw said that there are two tragedies in life. One is not getting what you want. The other one is getting what you want. Now, the trouble with Nigeria has effectively become the trouble of Bola Ahmed Tinubu. And for Nigerians, they have to probably move on, move forward, and hopefully hold Bola Tinubu accountable. So if you're interested in joining the conversation from any side, we welcome you. We want to know what you think. Were you surprised by the judgment? A lot of people are saying they were not surprised, but it didn't sound that way.
there appears to be silent, quietness that I haven't seen from one side of the divide. So let's hear from you. We are going to be live for a brief moment, and we will have our normal show on Saturday. And of course, on Sunday, we have a big guest coming on the show, but we will talk about that tomorrow. So once again, the ruling is in. Bola Ahmed Tinubu, confirmed by the Nigerian Supreme Court as a person who is duly elected president of Nigeria. They essentially dismissed all the appeal made by Atiku Abubakar and Peter Obi. Interesting times. And the next 4 years is all set to go. For people who support Tinubu, we want to hear from you. Are you happy now that the trouble of Nigeria is the trouble of your man? And for those who supported or are supporting Peter Obi, what are you going to do moving forward? So we will come back after a little break and have a conversation around these topics. So I hope to see you. Think about it. It's the fate of the country. It's on the
onye ọma zoro bio akwa nwa zoro bio Max ịbịa bunyego kwanu mo n'ofube n'azụ ụlaga n'ịbịa zugo mmanwụ ụlaga do n'ịbịa zugo akwa nwa ilochi yo biko rapụ zoro ka ọ nabazi ya onye ọma zoro biko abọmma nwatara ndasari ịbịa onye nịgwa na mụ ụlagado n'ịbịa zigo mma ụlagado n'ịbịa zigo abọmma nwe ilochila biko rapụ zoro ọ na-agbazi ya Mazi welcome up. Odogu no kwere nka. Onyo mani gadele mo. Mazi ni bazi kama. Ibu go with melody. Odogu na chala noka Ezi wane mliga delemo Olagado ni pezigono Ma olagado ni pezigo Amama wilo chilo Bikora muzoro Anabazi Te Onyama zoro Mama wazara nesari Ibya muyana kwa namo Doni Piazugo, Nazaboy. Maulaga Doni Piazugo, Amama Wilo Chilo, Biko Rapuzoro, Hanabazi. Odogu Kenano Bikechofo, Amakwa Nika Gogogia, Waligwe Kwelo. Get your mobile back. Hey, you want? Ebu kampune kene, omogo ndi nso. Chukwu emeka lumo, ike chukwu negaje. Esi nwanne m ekene dị ịlapụ ife niile na-eme wee bịa nke gosili na anyị na gị bụ nwanne Wisdom ga-adị ka nye gị maịkị ka ogobanya bụ egwu isili maxi ọ bụ na-etiri egwu a malụkwa malụ n'imego m ife ọjọọ wee sị gị nwanne m ife ọkụ na-echọlụ na ngeme Wisdom onume ekene gị gbamanwụ iyo biko lapụ nabasị ya zoro 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 zoro
All right, welcome back, and let's talk about these things. Maxi, how are you?
I'm fine, Dr. Damage. When are you going to stop damaging this people?
So,
wow. Good afternoon, sir, from here.
Yeah, how is it in Ghana?
We thank God. Everything is fine.
Okay, very good.
Only bad economy, and everything, but the rest is just okay. We don't have a good leader that is going to, bring us good business or economic policies that will raise people, where out from where they are right now. And to tell you about 8 regions. 8 regions in Ghana here is right now underwater because of the Akosombo Dam that was spilled, an act of negligence on the side of the VRA. Instead of them to spill when they're supposed to spill, they allow the water level to rise to a certain level. They have no other option than to open all the 6 valves, which has submerged some communities, 8 regions in Ghana, put them underwater as we speak.
That's sad. So what do you think about the Supreme Court's ruling?
Well, Dr. Dami, you know my position from the beginning. When this election was, they were preparing for this election, I told you my own opinion. If Nigeria cannot sit down, dialogue, and write what I call the People's Constitution, you see that military constitution that they gave you there is what they are hanging up to teach you about technicalities. Wherever you are, you people will see how elections are carried on, how people go and vote. All these shenanigans in the Nigerian electoral system is not there. Yes, there is no system that is going to be perfect, but minimize this nonsensical technicalities. 1999 Constitution, that military constitution, which I was an active member as well, is the bane of the problem of Nigeria. Nothing. I think I had is it Ugumado Uguma the other day on Arise, when he was telling Nigerians that 1999 constitution is not a federal constitution, it's a people's constitution. And I do not know how long we are going to speak about it. What is so difficult for Nigeria to campaign for a change of that 1999 constitution? That made everything, that made people corrupt. That constitution, that 1999 constitution has empowered people to be corrupt. That constitution, upholds impunity. That is what I see. And if Nigeria cannot come together to take a new path, remove that one, get what I call people's constitution, all these things will continue to go on. And we will cry and cry and cry. I'm crying simply because my mother is from there. My mother is an Igbo woman, a Biafran. That's the reason why I'm crying, because any horrible policy will affect my mother and the rest of my cousins over there. There is nothing that will come out of, nothing positive. Like I said it before, nothing positive will come out of it. And that is the reason why I said I use the Hope Uzodinma, the Imo State. I used it, and I will continue to use that. Make that as my reference point. This is what they replicated here right now. Who is going to charge them? A judiciary that has been corrupt, bought, and so on. In fact, the system in Nigeria now is the highest bidder will get everything. Bola Ahmed Tinubu has everything it takes to get whatever he wants to get. There's no doubt about it. Thank you, sir.
All right, thank you, Maxi. Ikena San Antonio, welcome. You're not smiling.
Dr. Tinjakere Damages. Papu Doka, don't mess with my smile, oh, Papu Doka.
You're not smiling. What's going on? Did anything happen today that we didn't know?
No. We are personally, I told all my family members, all my cousins, that it doesn't matter the amount of prayer you guys pray. Prayer cannot solve Nigerian problem. Nigeria problem is beyond Buhari, Tinubu, behind the governors. Nigeria problem is every Nigeria that live in Nigeria. Every Nigeria that live in Nigeria is only few that are not corrupt. People where go do you while you're in the market, they are corrupt. So the Igbo people says from head. So my brother, I remember when judiciary first did what they did, I came to your platform and I told you guys going to Supreme Court is just for formality, for P2B to have the idea that the Supreme Court can say you didn't bring it to Supreme Court. What happened today should not be surprise to anybody in Nigeria or anybody in Western world that are from Nigeria. The day Tinubu was sworn in is the day Tinubu was president, and Tinubu will be president for 8 years if he's alive. The only thing that will jeopardize 8 years of Tinubu not being president of Nigeria, unless if he died in the presidency. But if he didn't die in the presidency, he's going to be in for 8 years. A whole Mahmoud, who is incompetent, who calls himself professor, if he's still working and talking about the election in November, he's still talking about the election, the same IREV story, the same other story. Unfortunately, there is nothing anybody can do. Tinubu will remain president. People talk about constitution. They didn't even follow the stupid 1999 constitution anyway. Because if they follow the stupid 1999 constitution, we wouldn't even be here. So it's not constitution, it's people, it's tribalism, it's religious bigot. The biggest business in Nigeria is politics and being a pastor. Those are the biggest religion, the biggest business, being a pastor or Islamic crack. But all those things, is unfortunate that we are here. Nigeria is in the state of non-fix. Nobody can fix Nigeria. I raise my case, Dr. Jacqueline Damages, Papudo Kabiko.
All right, thank you. The Blackstone, welcome.
Good day, Dr. Damages.
Yeah.
How are you doing?
We're good. Did the story get to Germany?
I watched it live actually.
Okay.
So anyway, I wasn't surprised because I know being our judges, our Supreme Court, and everything being what they are, from history, from what they have been doing, their judgment and everything. I didn't see any big surprise from there, right? And then yeah, it's just a pity that we are still at least at 63 years of Nigeria, we are still having this issue. We are still going. It's like we have not even grown to stand for what is right, to stand for facts, to stand and defend ourselves and come out and say this is what is right, this is the truth. We still find a way to dribble around and decide to put who we support or who pays it, who's the biggest bidder on power, in power and everything like that. So anyway, I also think that even some of the lawyers for Obi or for Atiku also made a mistake. There are some errors in the make. For me, I would have even expected that they would have called for a recount. That would be that's my own take. They have called for a recount of those of the results, but nobody went through that route, because for anybody to defend or to try to fight against INEC seems to be a lot of their own. They do whatever they want to do. They put who they want to put there, and then so they tell you go to court, and so when you get to court, who are you going to meet in the court? Also, the people that are also supporting those that tells you to go to court. So at the end of the day, yeah, it is what it is. For me, it's a pity that Nigeria is going through a lot of troubles this time. People are dying, people are suffering, people can boast of 1 square meal a day, so it's just a pity. Today, $1 is 1,300 naira to $1, so I don't know how they are going to survive and how the economy, how they are going to improve on the economy. I don't see any positive things from this government, and I don't see there's going to be any positive changes. I don't know how they are going to improve on anything, right? It's like when you have criminals in power, everybody who are criminals stick to them, global around them, So that is it. So I'm not surprised about the judgment, and that was my expectation that the Supreme Court will not do anything positive or will not go against the lower court, and then so that is it. So that we are waiting for, like the certificate from CSU, the FBI report, and files and everything. So it's just somehow like waste of time anyway. So, but it is a shame that it is giving us a lot of baggages all over the world. Nigeria is how other nations look at Nigeria. How do they perceive us? How do they see us? So all these are just issues that at least sometimes we have to also consider. So anyway, they have done their best. They have done their judgment, and let's see what's going to happen between now and 4 years. And what I can say, Nigeria still have chance in 2027. They still have the chance to do what is good, and I think it is time everybody should come together and try to do some amendment to the electoral law, to the constitution. Let's see how we can change those things. They can't say INEC has the power to decide how they want to collect results, and IRF is not important. Why do they have to spend all that money to build up IRF and things like that? So that's just my take.
All right, thank you. Can do. Welcome.
Yes, good day, all.
You don't look happy.
Really... Can you hear me?
Yeah, I said you don't look happy.
My brother,
I want people to be.
I am happy, but I consider it a very sad day for Nigeria, and it did not actually start today. It started when 500 million or $300 to $500 million was spent on ensuring that we have a free and fair election. And I think part of the summation that they made today was that the electoral board had the right to decide whether the beavers were going to be used, that it ultimately rested with them. But for me, it's not even an issue of if Tinubu was the winner or Atiku was the winner. It was really all about ensuring that all the votes were counted. You know, in banking, they say not only do you need to be honest, you need to appear to be honest. So if you send me on an errand, I need to be able to bring you back a receipt that shows that this is what I paid for what you sent me on. Unfortunately for me, I had written back in 2015, based on the numbers that I look at, when the Naira was $1 to 187. I even wrote about it in Sahara, that in 7 years, it's going to go from 187 to 1,000. And again, in November of last year, when it was still around 800 and something, I wrote that this Naira is going to be 2,500 to $1 in less than 18 months. Because those are the numbers that I follow. Those are the things that I look at. And what surprises me is that all this Edungai, central bank, and all this economics and commodities administrators did not see what was happening during Buhari's administration. How they missed it is unbelievable to me. And that is what makes me feel that these guys, regardless of how brilliant they may seem on the surface, I don't get the feeling that they really have the tools that is necessary. And I have been telling people this, even if Obi was there, Naira is going to go to $1 to 2,500. Except if you have people that are not buying foreign cars for 160 million Naira. In this dispensation, with what we have on the ground, everybody should be using keke to go to work. Motorcycle, not bicycle, bicycles. They make the one you have to pedal is what they should be buying and driving. So we're not ready. Unfortunately, I mean, I will be pleasantly surprised if these guys can actually bring out the tools that will help the Nigerian people. People, Dr. Damages, the suffering has not started. This is only a preamble. In another couple of years, people will be on the streets because these guys don't have the tools. I hope they prove me wrong. I really hope they prove me wrong. But from all the indexes that I look at, it's not going to happen.
All right. Thank you. So this is what we know today, based on what happened today. Transmission of results are no longer expected. It's not mandatory. It's not important. 25% of Abuja, winning 25% in Abuja is not needed for you to be president.
It's dead.
Yeah. So the next question is, so what happens to supporters of these candidates? What are they going to do next? Maxine.
Yeah, thank you, Doctor. The only thing I'm going to say here is my own opinion, and I do not know of another person. What I would say, let's say Nigeria is not like my own country here, Ghana. It takes a great deal for a police officer to ransack or shoot at sight protesters or do them the way they do them in Nigeria. And not just that they would, pour tear gas on them and so on and so forth. Sometimes they level their barrels on them and release balls, munitions on the innocent protesters. So that is what I will not encourage the supporters of the losing side to do. Don't do it. Don't dare do it. Because these people would do everything to cement that corrupt position that they have taken. By crook or by any way, known to, any means known to them. They have, how did Bola Ahmed put it the other time? He said, grab it and run away with it. They have grabbed it and they are running away with it. If you try to stop them by any civil disobedience process, they are going to unleash mayhem on the people. If they decide to go to protest on the street of Nigeria, no problem. But for me, as someone who has served in the army before, our people are ruthless when it comes to dealing with protesters. They do not know. They don't have the professionality to deal with protesters. And you can see it in the past, the IPOB agitators, how they manhandled them, how they shot at them, how they leveled so many of them as we speak today, and they are still doing it. You saw what happened at Lekki. You saw what, in fact, everywhere. I would not encourage any sane Nigerian to go on the street. If you go on the street, you might not come from alive. Thank you.
All right. Thank you.
It's unfortunate.
Victory.
Hello, doctor.
How are you?
I'm good. Greetings, everyone. Maxey, Blackstone, at Kando. Greetings, everyone.
Greetings too.
So, Victor, what is your take on what happened today?
Doctor, I was just laughing. Like what you said, 25% is no more needed, shredded. What's it called? There's no more electronic transmission. And I'm sitting there hearing Blackstone saying that we should re-strategize for 2027. I'm thinking, Baba, do you understand what's happening in that country? They're telling you that the small one that they passed last year, how many years ago, that is no more needed. So people will just come and write result in a sheet of paper and give you that. That is the result. That's it. So I think Nigeria is fighting for, everybody is like, Nigeria is literally fighting for its soul. I suppose what I can see is someone telling you that the strongest will survive. So if you want to take that power, then you have to come up. You have to go and fight. Any other miss, any miss, go and fight, and then grab the power. Because there's nothing such as the rule of law. People just do what they like. So anyone talking about 2027, you should go and really examine what they are talking about, because I can guarantee you that it's not going to be 2027, and Nigeria is going to just be like a state that it will just be going down the drain, because these people that are there will keep on making mistake. The economy will keep getting bad, and everybody will just be scrambling to run away from the country. But I'm hoping at a point the people will react that, listen, we've had enough, and that's it. But I don't know when the people will get to that point. So it's just a matter of time. But I know that the people that are there right now, they will just keep making mistake, and the country will just keep going down the drain, because I can't see any solution from those people. So that's what I have to say, Doctor.
All right. Blackstone.
Yeah. Thank you, Doctor. Victory, let me let me correct what I said. I said that when I talk about 2027, I said we cannot be preparing to make some amendment to the electoral laws and also the constitution, right, before 2027, right? So that's what I mean by what I said, right? And so for me, I don't know what the people will do, but I think there's a saying that when the dog will bite his owner when he push him too much to the wall, right? And that is what Nigeria is now becoming, right? They are pushing too hard on Nigerian people, and I think very soon it's not going to be long, right? They are going to take the law into their hands, you know. And I know that even after this judgment, I know that some group of people might be thinking of what to do, not because of the judgment or the rulings, but actually the economic situation in Nigeria is very, very bad, and that is what is going to precipitate this. What's going to happen next, right? And the people are not finding it easy, and I think there's going to be a lot of disturbances, there's going to be a lot of demonstrations, a lot of riot. In fact, I think what happened in what they did during the EndSARS should be just a iceberg, just a small thing, right? And what's going to happen this time, I think it's going to be really bloody. People are going to go out and take the law into their hand, you know, and because people are really hungry, people are suffering, and they can't bear it anymore, right? What I wanted to ask, can do a question, right? I think what the central bank or they are doing, I think it should be I think that's a deliberate something, not that they don't know what to do or how to put the laws or how to develop the country, how to put laws in place, how to make this work out. I just see that a deliberate something. Look, let's take for example the issue of power. I don't see any reason why Nigeria cannot be able to produce stable electricity at this time of development in the world. So it's a deliberate something. That's what I think it is. You know, that's what I think. They know that a country that has no power, they know how you are going to encourage production. Right, I don't see any reason why this man can remove the restriction on this 43 items, you know, and these 43 items are now actually push up the dollar rate because the people because there's less supply and there's more demand and less supply, you know. So I think all these are just deliberate attempt to please their group, their cabals and everything, which I think that this I think everything Nigeria is just like it is our turn, it's my people. So let us please our group, you know. That's what is happening. That's how they are ruling the nation. Like you said, at least I'm supposed to learn from the mistake of Buhari, but this is even worse than the mistake of Buhari regime mistakes that was done during the Buhari regime, you know. So I think all is just being deliberate, actually. What they are doing, their policy and everything, they know what they are doing, and they are using to punish the people, to suffer the people, and things like that. Tinubu is there. It's a criminal, you know. He knows how to play his game, you know. So there must be a reason behind all these things. That's what I think. That's my point of view.
All right. In another 5 minutes, I have to leave. I have to go and teach post-colonial African history.
All right, let me respond to Blackstone. Let me respond to Blackstone real quick.
Yeah, I will. I'll come to you. Can do.
Rudolph, let me ask a question, please, before you move on.
Okay.
But Ify, have you been able to, because you have not been on the platform for a very long time, Ify?
No, I've not seen her.
No, she was Ify. She was here on Sunday.
Okay.
Yeah,
oh, really?
She was here on Sunday.
Okay.
Yeah.
Yeah, I don't know. I don't stay all through, so most of the time.
Yeah, I know. I wasn't here on Sunday actually. Yeah.
Okay. All right. So, like I said, I will leave in about 3 minutes. Unfortunately, I have to go and teach African history, but I will teach, instead of teaching the past, I will tell them what happened today.
Today, present.
And
So, doctor.
Yeah.
They didn't send you any money from the 160 million car. Why are you so
they didn't what?
They didn't send you any money from the 160 million car. Why are you still teaching?
Why are you teaching?
Now, one thing that is important is question to ask is Atiku, is he going to retire? We also know that Bawa, the former EFCC chairman, was freed today after 133 days in DSS. Yeah, go ahead, Maxi.
You see, it was just the election, the Supreme Court case that we are reviewing just took my time. I would have speak about that release. You see what is going on. Dr. Damages and all my brothers and my senior brother that is here with the red cap. Have you seen what the system is doing to our people? A police officer who recovered, properties for the government. Look at what they did to him. What of Abba Kyari, the drug cap? Where is he? But where is Mazen Nnamdi Kanu today? It's like everybody have just forgotten about Mazen Nnamdi Kanu. And none of them, Mazen Nnamdi Kanu did not commit what these people committed against the state. You see how they treated them? They left. But Mazen Nnamdi Kanu is still in that DSS. After these same corrupt churches at the Court of Appeal pronounced him discharged, and our people cannot make a case for that man to be released. Today they are releasing their own. This is to tell you that in fact, nobody regards, where my mother come from, nobody regards them anymore. They know you, they don't know you finish. And they can do anything at any time against you, and nobody will speak for you. That is what I have seen. And that is a very bad, it is a very bad precedent. And that is why you see even people who are warlord that has attacked facilities of coming out to speak nonsense about the Igbos.
Yeah, well, I mean, unfortunately, that is what is.
I am so sorry about. In fact, I am angered about that. So thank you.
Yeah, that is what's been going on in our dispensation for decades. Like the saying goes, when they come for your neighbor and you say nothing and do nothing about it, when they come for you, there won't be anyone to say or do anything. And at Mr. Blackstone, look, these people are not intentionally trying to sabotage anything. They're just inept and incompetent. This is not about anybody trying to do anything foolish. It is, you have to be beyond stupid to be buying cars of 160 million in this situation. That is like, that is like you haven't paid your house mortgage in 1 year, and you have 4 cars sitting in front of your house. That's foolishness. This, I'm telling you, unfortunately, I pray they prove me wrong. But you see, what I do, I look at economic indicators. And the ones I've been looking at for the last 7 years, these guys, the only way that I know of that they can stop this thing is to sell some assets and pay some bills. You cannot borrow your way out of this situation. And that's really all they have. And I think the only other thing they're talking about is taxing people 5% on their income. They're bringing back the Lagos playbook, tax everybody to death, which will be fine as long as they have an income. Where are they going to get the jobs to pay the tax?
All right. Thank you. Last word to you, Victory.
Yeah, Doctor, I was even saying that you have the mind to go and start teaching people about Nigeria. What are you going to tell them? I'll tell you what, Doctor, I was in class the other day and was doing something about the court here in the UK, and some guy wore one Nigerian guy wore the those that hair, this the
wig and everything, the wig, yeah.
I'm looking at the guy. I said, this guy looks like Justice Tsunami. I started laughing. Like I said, if it's Nigeria now, these are people that will pass the judgment. They would see A, they would say it's B. I was like, Dr. Nigeria is a joke. Like, it's a spectacle of, like, you can't just imagine what will happen. But like I said, the people that are there right now, they will keep making mistake on mistake. What Obi have done for the people is to let people see that this system is completely rotten and nobody can save Nigeria. I'm sorry to say, Doctor, anybody that is there, they are just wasting their time. All we're doing is we're just waiting for the day until that country just goes apart. Yeah, there's no solution. So Nigeria, that's it. Nigeria is done. If you can say what is white is black, and there are people that are actually standing behind those things, looking at it, you're seeing injustice, and you're looking at it and you're egging it on that go right on, will support you, then it's just a matter of time. The people that you're doing injustice to, when they storm you, it will be carnage. That's what I have to say.
All right, thank you, Victory, and I want to thank everybody that joined me. It's unfortunate we don't have any moderator around, but maybe whenever one of them is ready, they can come on and continue the conversation. But I have to run to go to the city. Thank you, Maxi, for joining us. Blackstone, thank you so much for joining.
Thank you, Doctor.
Thank you, Kandu, and thank you, Victory. And those who are watching at home, thank you so much for joining us. We will be back on our regular show on Saturday, and on Sunday, we have a big guest joining us on Sunday. So if you can, please join us, and I will see you then. Thank you.
Enjoy yourself in New York.
All right.